On behalf of All India Trinamool Congress, under the leadership of the Mamata Banerjee, I strongly oppose the bill in entirety. Madam, the spirit of my speech is, तू हिंदू बनेगा ना मुसलमान बनेगा, इंसान की औलाद है, इंसान बनेगा. Madam, this present bill covers importantly two areas of the Waqf. One, manage religious affairs of Waqf board. One of the arena is to manage, control, supervision of the religious aspects of the Muslim. Two, providing power to the state government to decide the disputes in respect of the Waqf property, including land and building. Article 26 of the Constitution of India provides that, subject to public order, morality and health, every religious denominations or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purpose, B, to manage its own affairs in matter of religion, C, to own and acquire movable and immovable property, D, to administer such property in accordance to such law. Madam, the Waqf is an institution for religious and charitable purpose. The Muslim have constitutional right to manage its own affairs in the matter of religion because Waqf property belongs to Allah. They have also the right to administer such property. The purpose of the bill is a clear breach of the right of the Muslims to perform their religious duty, to manage their religious affairs, and therefore completely in violation of Article 26 of the Constitution of India. The bill hits basic structure of the Constitution. Madam, under Article 246, Sub-Article 1, the Parliament has an exclusive power to legislate a law under 7th schedule of List 1, and under Article 246, Sub-Article 3, the state is having the power, state legislature is having the power to legislate the law, exclusive power. Sir, excuse me, sir. That is to say, land comes under List 2, under entry 18 of the state lists. Lands and buildings vested in or in the possession of the state comes under entry 35 of the List 2 of the state list. In the proposed Waqf bill, the Parliament has no power to legislate any law in respect of the land and building vested in possession of the state in respect of the Waqf property, because the state is only having power to legislate such law. Therefore, the Parliament is now encroaching upon the power of the state legislation in deciding the question of the land and building of the Waqf. Thus, it is completely unconstitutional and dehones the Article 246, Sub-Article 3 of the Constitution of India. This is also hits the basic structure of the Constitution. By exercising any power under List 1 or List 3, state legislative power under List 2 cannot be encroached. There is a difference between a Waqf recognized by the Muslim law and religious endowment and the recognized by Hindu law on the one hand and public charitable trust as contemplated by the English law on the other. The question has been considered by the Privy Council in Vidya Bharati Tirtha versus Gulswami Iyer, long before. Mr. Amir Ali, who delivered the judgment of the board, observed that it is to be remembered that a trust in the sense in which the expression is used in English law, when the gift is directly to an idol or a temple, the season to complete the gift is necessarily effected by human agency, called by whatever name he is only the manager or custodian of the idol or the institution. In no case is the property conveyed to or vested in him. Similarly, that is a basic difference. The Honorable Minister, he was speaking about the Hindu trust. The Muslim law relating to trust differs fundamentally from the English law. Hindu trust follows English law. Muslim law doesn't follow English law. That is a basic difference. Mr. Amir Ali said the Mohammedan law owes its origin to a rule laid down by the Prophet of Islam and means the tying up of a property in the ownership of God the Almighty and the devotion of the prophets for the benefit of the human beings. As a result of the creation of a waqf, the rights of the waqif is extinguished and the ownership is transferred to the Almighty. It is religious. If it is religious, comes within the ambit and scope of Article 26 of the Constitution. The manager of the waqf is the Mutawalli, the governor, superintendent, curator. But in that capacity, he has no right in the property belonging to the waqf. The property is not vested in him and he is not a trustee in the legal sense. Therefore, there is no doubt that the waqf to which the Act applies is essentially features different from the trust as is known to English law. In Saira Banu versus Union of India, 2017, volume 9, SCC, page 1, the Constitution bench held that any legal provision should be made with the application of known principles of law. If any decision is taken without supporting principles of rule of law, it becomes unpredictable and such a decision is antithesis of a decision taken in accordance with the rule of law. This proposed bill is just contrary to the well-settled principles of law which is established in the country by judgments have been pronounced not only by the Privy Council, by the Supreme Court of India also. Madam, the various provisions of the Waqf Amendment Bill 2024 is manifestly arbitrary and therefore cannot be passed by the Parliament itself. The Waqf system in Islamic tradition stands as a testament to the enduring values of charity, community, welfare, spiritual dedication rooted in the principles of Sadaqah Jariyah. Waqf in India, Waqf properties form the backbone of the Muslim communities, social, cultural and religious life, playing a pivotal role in maintaining their collective identity. This endowment sustains mosques, madrasas and cemeteries while providing essential resources to marginalized section of society, especially in an environment where minority communities often struggle for equitable access to public purposes. This is not there. Equality, equitable access is not there in case of the Muslim. That is the reason we are opposing.